What matters is what we're going to talk about today. I did a little breakdown of the Supreme Court opinion last week. I enjoyed it, and I think this is a very significant day for the Supreme Court because you may know or may not know what the court did today. The court, once again, on what's called the shadow docket, the emergency docket, the court greenlighted something that the Trump administration is doing that is highly problematic under the Constitution, you might say, that is quite likely under a normal reading of the Constitution, unconstitutional. So what happened was that this is all about this case. This is called Kristi Noem versus Pedro Vasquez Perdomo and others. So that's the one we've got right now. And this is about, this case is about what's going on in Los Angeles. ICE agents raiding all kinds of places, looking for basically anybody they can round up. And it's about how they go about doing that, right? We've all seen these videos, so disturbing. I think they will be a permanent stain on our country. And I think it'll be akin to the internment of Japanese Americans. I think everyone who is involved in this, everyone who supports this, will one day be shamed in our history. Their grandchildren will be ashamed of them because we all see it. This is who the United States is in the eyes of the world, but we can't let it stay that way. At any rate, part of the battle that's going on is in the courts and in the Supreme Court. So what did we learn today? All right, so the case is about by what justification do the ICE agents in Los Angeles tackle, bash in the window, round up people on suspicion that they may be here unlawfully? All right, so if you're not here with proper papers, if you're here illegally, right, you're subject to our laws. That's not racism. That's not a problem. That is, in fact, democratic self-government. But how we do it, how do we find people, and how do we prioritize our law enforcement to enforce the laws, which people have a right to do, the country has a right to do? And so in order to start this discussion, this case, Kristi Noem versus Vasquez Perdomo and others, I wanted to go all the way back to 2013 and one paragraph written. Well, I'll ask you who you think you might this. So this is a case called Maryland versus Alonzo J. King. And it's a very important case back from 2013. And it's the case that allowed law enforcement agencies around the country to take your DNA, to swab you when they stop you or pull you over. Okay. And they don't need a search warrant for it. It's considered a non-intrusive search. Seems pretty intrusive to me. And in dissent, this is the first, it was a 5-4 decision. Chief Justice John Roberts saying, sure, what's the big deal? And in dissent, this was the first paragraph of the dissent. The Fourth Amendment forbids searching a person for evidence of a crime when there is no basis for believing the person is guilty of the crime or is in possession of incriminating evidence. That prohibition is categorical and without exception. It lies at the very heart of the Fourth Amendment. Whenever this court has allowed a suspicionless search, it has insisted upon a justifying motive apart from the investigation of crime. So who wrote that? Justice Antonin Scalia, the great conservative. And he rested it on the original. He said at the time of the founding, Americans despised the British use of so-called general warrants. Just, warrants not grounded upon a sworn oath of a specific reason to suspect someone, but just kind of, well, we're going to go search that guy's house. Americans hated that. That's why the First Amendment came. So that's the preface. Justice Antonin Scalia, 12 years ago. Today, the court reached a very different conclusion, but only really on this shadow docket. This case didn't come before the court in a normal way. By this time, I'm sure you know that something is wrong in the way this court is operating under the Trump administration. I believe this was the 18th straight win for Donald Trump in the high court, but the vast majority of those are this emergency docket. the case is not coming to them on a normal process. What's normal process? Well, something happened, somebody's arrested, somebody has been wronged, whatever. There's a challenge to the exercise of the power of the government or what is happening in the law. And that first goes to a district court. The district court hears motions. One side wants to throw it out. The other side wants to throw it out or pursue it. The court issues an order. No, we're going to go forward with this trial. We're going to go forward with this case. That can be appealed. Hey, wait, we don't even want to go to trial. We think we've got such a strong case. District court was wrong. We want the appeals court to cut it off. And the appeals court says, well, you're in that rare category where the district court got it wrong, and the remedy for you is we're going to throw the case out, or we're going to bring it back. And then they might not like that result. So we're going to go all to the Supreme Court. Remember, this came from the trial court originally. Supreme Court says, get out of here. I mean, it never used to do this. Reach all the way down into the district courts or take a case that percolates all the way up from the district courts and say, we're overruling the trial judge before the trial begins. They do it all the time now, all the time. So the facts of this case, this comes out of those ICE raids in Los Angeles. And for the facts, I'm going to turn to the dissent here. It won't surprise you that the dissent is both written by Justice Sotomayor, who has become the great dissenter of our time. If you haven't, read her dissent in Trump versus U.S., the immunity case. It's one of the great dissents in which she tears apart her conservative colleagues for departing altogether from the Constitution and just supercharging the presidency of Donald Trump. And she was warning of what it might entail, and she was right. So here are the facts as Justice Sotomayor recounts them. In early June, the government launched an immigration enforcement raids across Los Angeles and its surrounding counties. During the raids, teams of armed and masked agents pulled up to car washes, tow yards, farms, and parks and began seizing individuals on site, often before asking a single question. Federal District Court found that these raids were part of a pattern of conduct by the government and stopped them from continuing those kinds of raids. Because the District Court found that the government was stopping individuals in Los Angeles County, this we all know, but think of it in terms of our Constitution and law, on 4 factors. Federal government is using 4 factors in Los Angeles to tackle people, right? To break into businesses and round them up, to chase them down in wherever they might be, get into their cars. What are the 4 factors? 1, their apparent race or ethnicity. There's no such thing as race, okay? I'm just going to say there's no real, I know it's a social construction, and even that's stupid. It's a stupid concept. At any rate, it's hammered into our law because it's hammered into our society. Their apparent race or ethnicity, whether they spoke Spanish or English with an accent, the type of location at which they were found, such as a car wash or a bus stop, and the type of job they appeared to work. And the trial court back in July said, this is not good enough. The Fourth Amendment, which we should actually read, but the Fourth Amendment, which protects you from unreasonable searches and seizures, requires more of the government than, kind of brown. It doesn't speak English that well. Is it a car wash or a bus stop? And they're kind of a laborer type. They're kind of a working class guy. They're probably illegal, or at least we've got a reasonable, judgment call to say they are illegal. Well, the trial court said, no, that's not good enough. All right. And so the question then came to the appeals court, because the Trump administration said, wait, this is important work nationally. And there's no question, we lost control of the border. And a lot of that was Joe Biden's fault, right? And the Biden administration's fault. There are estimated, Pew, which is a pretty good outfit, says 14 million. That's as of 2023. So a fair guesstimate is 15 million people are in our country without the benefit of the protections of law or the obligations that they might have under law. They are living in the shadows. And we are seeing how vulnerable they are to a certain kind of viciousness that is now abroad in the land. And so solving that problem is an important government interest, should be done as it has been crying out to be done by the Congress. But for a generation now, the Congress has been unable to move on that. All right. So that's the factual background. That's the procedural background. The district court says, got to stop these raids because people's skin color and their language is not good enough. Goes up to the appeals court. The appeals court basically says, trial court's right. You can't continue these kinds of raids. And so, we're going to side with the trial court, go back down, normal, regular procedure, have a trial, bring witnesses, take depositions, look at the facts. How is the government actually behaving? Who are being rounded up? What kind of injuries are being incurred, physical or otherwise? What's the success rate? What are the different interests of the government and the people who are out on the streets of Los Angeles? And then the district court will come to a verdict. We'll look at it like in a normal course of business. But the Trump administration came right up to their friends, their good friends at the United States Supreme Court, and said, we don't like the trial court's order. We don't like the appeal court upholding that order. And we want the Supreme Court to stop it all. Let us continue our law enforcement operations, so-called, as we snatch these people, including children, away and take them away God knows where, send them God knows where. And the Supreme Court today, without a formal opinion, this is very important. This is not an opinion of the Supreme Court. This is an unsigned ruling in the Supreme Court, an order that basically says the district court was wrong. The government can continue enforcing this law the way they want. ICE can do its work the way the government wants them to do it, and the trial can continue. Now you go hold a trial. So in the meanwhile, right, there'll be plenty of people rounded up and wrongly, probably, many of them, as we know this is not a highly accurate business at this point. So that's how it came to the court, and the court disposed of it saying, no, government can continue. The trial will come when the trial comes. Meantime, you guys keep going. But there were two opinions in this case. Not opinions on a fully briefed, factually based ruling, but on this shadow docket, lifting the stay on the emergency docket without a formal statement by the court. But two justices decided this was so important, they wanted to speak out. The first was Justice Brett Kavanaugh. And I want to take a look at his opinion and then Justice Sotomayor's opinion and what it tells about the Supreme Court right now. I'm going to have a little sip of water because these guys are pretty wordy, and so am I. Now, what I want you to listen to here is the level of generality and the level of specificity that Justice Brett Kavanaugh uses in describing this. Put in your mind and put in your heart the scenes that we have seen in Los Angeles and elsewhere. See those people getting rounded up? Hear their cries? That's your government operating in your name. And this is how Brett Kavanaugh describes it and justifies it. So he says the Immigration and Nationality Act permits and authorizes immigration officers to interrogate any alien or person believed to be an alien as to his right to be or remain in the United States. Immigration officers may briefly detain an individual for questioning if they have a reasonable suspicion based on specific articulable facts that the person being questioned is an alien illegally in the United States, right? So even in Congress's law, which tends to be pretty general, the Congress thought, we don't want people just rounding people up because they're brown or they don't speak English well. We want there to be specific articulable facts that would lead to a conclusion. No, it's not a high barrier. It's not beyond a reasonable doubt. It's not even preponderance of the evidence. It's just you got to have a reasonable grounds for conducting this questioning of somebody, and those grounds have to be articulable in fact. Okay, so that's really what the law says. But the court over the years has gone beyond that. So and we'll hear about this case, U.S. versus Brignoni-Ponce. That's a 1975 case in which a car came across the Mexican border, driven by Mr. Brignoni-Ponce, who was actually Puerto Rican and American citizen. Had a bunch of people in it, and they tracked it down as they saw a bunch of brown people in a car, and cops pulled them over. They asked the people who they were, what they were doing, arrested all of them. And the case went to the Supreme Court. There was no warrant for questioning these people. There was no reasonable suspicion. And the court agreed. And it was 9-0. It was 9-0. That was the Burger Court. There were some pretty conservative people on the court in 1975, but it was a unanimous opinion. You can't just have immigration officers looking in a car as it goes past and tracking them down and stopping them and looking at them and saying this is a legitimate stop. So that's the foundational case in this line of doctrine. So then the next thing that Kavanaugh talks about, after he says, here's what the law says, Congress passed the law, he basically gives the Trump administration talking points. He says this: the government estimates that at least 15 million people are in the United States illegally, many millions illegally entered or illegally overstayed just in the last few years. He doesn't like Biden's enforcement of our immigration laws. Neither do I, frankly. I thought it was ridiculous, and it's going to backfire on the Democratic Party for a long time. Then he goes on. Illegal immigration is especially pronounced in the Los Angeles area, among other locales in the United States. 10% of the people in the Los Angeles region are illegally in the United States, meaning about 2 million illegal immigrants out of a total population of 20 million. So, not surprisingly, given those extraordinary numbers, U.S. immigration officers have prioritized immigration enforcement in Los Angeles. The government sometimes makes brief investigative stops to check the immigration status of those who gather in locations where people are hired for day jobs, who work to or appear to work in jobs such as construction, landscaping, agriculture, or car washes that often do not require paperwork and are therefore attractive to illegal immigrants and who do not speak much of any English. If the officers learn that the individual they stopped is a U.S. citizen or otherwise lawfully in the United States, they promptly let that individual go. What planet is Brett Kavanaugh on? Dozens, at least as far as we know. So much of this is done in the shadows. We don't really know who's getting rounded up. Dozens of American citizens have been rounded up and detained and sometimes disappeared for weeks. There was that lady in Massachusetts. For weeks. Her lawyer couldn't get a hold of her. Her husband couldn't get a hold of her. For weeks, she was disappeared into the gulag. What else are you going to call it? I know, that's probably hysterical, whatever, but I don't know. In the United States of America, a U.S. citizen is snatched from the streets, disappeared into a prison for weeks, with no access to processes of law, with no access to a lawyer, with no access to family. What do you call that? Anyway, Brett Kavanaugh doesn't call it anything because he can't see from his perch on the Supreme Court of the United States. Once again, Kavanaugh, if the officers learn that the individual they stopped is a U.S. citizen or otherwise lawfully in the United States, they promptly let the individual go. Onward with Kavanaugh. He says the district court stopped all of this. And he says, but that's not lawful because the bar to get what's called, a permanent, an injunction, temporary an injunction to stop the government from doing it is pretty high. There has to be irreparable harm. He says the government is suffering irreparable harm because it can't conduct these kinds of raids. What's the harm? You got to define it. He says, given the significance of the issue to the government's immigration enforcement efforts, this court would take this case. So in other words, he's buying into the agenda of the Trump administration. I'm not sure he would have done the same with the Biden administration. And then he goes on to say that that the government always suffers irreparable harm when it cannot effectuate the enforcement of a law. Fair enough. That's true. You want the government to be able to enforce the laws. Is it irreparable, though? Is it really? And he goes on to say the government's going to win. And he says this is the meat of his opinion. This is Kavanaugh still. Stop an individual for brief questioning. This is what he calls these masked, armed men. We've seen these people. One thing I heard from a friend who's in the military police, is that a lot of these new hires for ICE are corrections officers who are kind of the low end of the law enforcement. They do a great job. That's tough work. Qualifications aren't high, neither is training, and so they're getting some very raw people into enforcement. Anyway, so Kavanaugh says to stop an individual for brief questioning about immigration status, like it's a little, like I'm going to inquire about the status of my property taxes down at the clerk's office. To stop an individual for brief questioning about immigration status, the government must have reasonable suspicion that the individual is illegally present in the United States. That's the black letter law. Reasonable suspicion is a lesser requirement than probable cause, considerably short of the preponderance of evidence or beyond a reasonable doubt. Sure. You got to look at the totality of the circumstances. And here, Kavanaugh says, the totality of the circumstances are the high number of percentage of illegal immigrants in the Los Angeles area. Well, that has nothing to do with the person you're tackling. That those individuals tend to gather in certain locations to seek daily work. That's pretty remote. That those individuals often work in certain kinds of jobs, and that many of those illegally in the Los Angeles area come from Mexico or Central America and do not speak much English. To be clear, Kavanaugh says, ethnicity alone cannot furnish reasonable suspicion under this court's case law. Of course not. We're still the United States of America. But if you add in all that other stuff, it amounts to reasonable suspicion. And one factor can be that they've got a Spanish accent. So, then goes on to say, under this court's precedents, not to mention common sense, those circumstances, if you take them all together, can constitute at least reasonable suspicion of illegal presence in the United States. Reasonable suspicion, he says, once again, somewhere on a different planet, means only that immigration officers may briefly stop the individual and inquire about the immigration status. Is that what you're seeing? Are you seeing people briefly stopping suspected unlawful immigrants and inquiring with them? Or are you seeing them manhandling them, throwing them to the ground, zip tying them, men, women, children in some cases? I don't know what plan once again, this Pollyanna justice, Pollyanna when he wants to be, Pollyanna justice, if the person is a U.S. citizen or otherwise lawfully in the United States, that individual will be free to go after the brief encounter. Once again, there are people locked up. We don't even know how many who are United States citizens. We'll hear more from Justice Sotomayor on that in a minute. So, the government has demonstrated irreparable harm by not being able to force this law. And it will chill lawful immigration efforts, he says. And that is Justice Brett Kavanaugh giving the green light from him. Now, once again, this is not the opinion of the court. This is just Brett Kavanaugh saying, hey, I vote to lift the district court's injunction against the government doing this stuff. I think the government should be allowed to do this stuff while the case continues down below, because the interests of the government are very important, because they're doing it nicely, really, and it's reasonable. It's more or less reasonable. You're brown, you can't speak English the way I speak English, and the rest of it. And he says, once again, the interests of the illegal immigrants in evading questioning are not particularly substantial as a legal matter. Fair enough. Moreover, as for stops of those individuals who are legally in the country, the questioning in those circumstances is typically brief, and those individuals may promptly go free after making clear to the immigration officers that they are U.S. citizens or otherwise legally in the United States. What planet is he on? I mean, I'm being too harsh on him, maybe. And, this is not the way I'd broadcast it on ABC, but this is the way I talk to it about my colleagues when they'd say, well, so what's this going on? I say, well, Kavanaugh is on another planet here, but he wins because that's where the Supreme Court is. They want to greenlight the Trump agenda. And that's not because they're all signing on to it, I don't think, although many of them are, there is abroad in our country an urge for enforcement, right? That's why Trump is so insistently talking about immigration crime, immigration crime, immigration crime. It makes a certain kind of person feel good. And you got to stop crime. You got to get control of the border. But Trump takes that legitimate concern and he turns us into something darker. I mean, is this really who we are? Is it really? This is some new horrible reality, says Vicky. Thank you. I mean, and that is, says remedies should be available if people are manhandled and abused. So that is Justice Brett Kavanaugh's opinion. We don't know what the rest of the court thought, but it seems pretty clear they are keen on greenlighting the Trump agenda. Now, our great dissenter. Over the course of Supreme Court history, there have been great dissenters. Scalia was one of them. Thomas has had a lot of dissents become law. Whether they like it or not, he's shaped the law from dissent. We have to hope Sonia Sotomayor joins Oliver Wendell Holmes in his better opinions, free speech opinions, and others in seeing her dissents, once we get past this fever, be looked at by a different court, or maybe the same court which has remorse, because here she gives the grounds for why Kavanaugh is wrong, and the district court should at least be allowed to do its business without the Supreme Court overturning its order at the ground level. And she begins, Justice Sotomayor, with the reality. Remember that Kavanaugh began with this: immigration's a problem. Illegal immigration is a problem in this country. I agree. I think most Americans agree. I think Biden lost control of the border. I don't think it was a good idea. It was also, after the pandemic, that border represents been in 86 countries around the world. That border between the United States and Mexico represents the largest wage differential across any border in the world. Okay, so think about that. There's going to be natural pressure on there. American people have a right to pass laws to decide who comes in and how many and when and how. There's a way to do it and there's a way not to do it. Biden didn't even do much of it until the end of his term. Obama tried, right? And he tried to get the Congress to do something, as did Biden. And Trump stopped all that. So here's how Justice Sotomayor begins. In early June, the government launched immigration enforcement raids across Los Angeles and its surrounding counties. During the raids, teams of armed and masked agents pulled up to car washes, tow yards, farms, and parks and began seizing individuals on site, often before asking a single question, right? So that's Sotomayor. Did you hear any of that factual language from Justice Kavanaugh? No. And I say this a lot because I believe it to be true. That at this point in our history, the most important thing each one of us can do is actually see the thing that is happening in front of us and name it. Justice Sotomayor does this here, and I think wins the case. So she says the federal district court found that these raids were part of a pattern of conduct by the government that likely violated the Fourth Amendment. Government was stopping individuals based solely on their apparent race or ethnicity, whether they spoke Spanish or English with an accent, the type of location at which they were found, the type of job they appeared to be working at. And so they stopped the government from continuing this pattern of unlawful conduct. She says today, instead of allowing the district court to consider these troubling allegations about what the government's doing, we're seeing it, right? Instead of allowing the district court in Los Angeles to consider these troubling allegations in the normal course, a majority of the court decides to take the once extraordinary step of staying the district court's order. Once again, the Supreme Court didn't used to reach down and stop a district court from holding a trial every once in a blue moon. I think it happened 14 times, well, like once a year before Trump came into office. And then there were quite a few, Trump pushes the boundaries, if not breaks them. And so there were more cases involving it, but the court never used to do that. And she goes on to say, Justice Sotomayor, that decision is yet another grave misuse of our emergency docket, that shadow docket. And here's her line. We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job. Rather than stand idly by while our constitutional freedoms are lost, I dissent. So she speaks from the heart there. And one of the things that I have often said about the Supreme Court is that, yes, it sits as a court of law and it can't leave law, but law is not an arithmetic. Law is not an equation. Law is our life, how we have chosen to live our life under law. But you have to look at how that is actually happening. Brett Kavanaugh deliberately or ignorantly turns away from the actual facts on the ground that have already been ascertained by the district court, but even more than that, are in front of all of us, right? Justice Sotomayor does not turn away. And it's very characteristic of her jurisprudence that it feels grounded. I've said for a long time, stop appointing and nominating and confirming to the bench the same type of person, right? I hate to say it. 8 of the 9 went to Ivy League colleges. They're all federal appellate lawyers. Sotomayor was a federal prosecutor, and you can feel the grit in her opinions from that. The others are all kind of cloistered monks of appellate law. Why isn't there a landlord-tenant lawyer on the court? Seriously, why isn't there a United States senator? I've been through this, a governor, somebody who's got life experiences beyond the incredibly remote precincts, remote from real life, of appellate law. Justice Sotomayor obviously brings her own personal experience here as a Latina to this case, as she properly should. And so she says it plainly. In early June, the government launched Operation at Large in Los Angeles, deploying roving patrols of armed and masked immigration agents. Again, armed and masked, something Kavanaugh never talked about. She said, for instance, she says, and she then gives these concrete examples that were ascertained by the district court. So this is in the court record. On June 9th, immigration agents arrived at a tow yard in Montebello carrying handguns and military-style rifles. Jason Gavidia, a Latino U.S. citizen, was working on his car in the tow yard that day. Jason, a Latino U.S. citizen. A masked agent ordered Gavidia to, quote, stop right there, and began asking him questions. Agents then asked Gavidia whether he is an American at least 3 times. 3 times, Gavidia affirmed that he is. Unsatisfied, the agents asked Gavidia for the name of the hospital in which he was born. And when Gavidia could not immediately recall, the agents racked a rifle, took Gavidia's phone, pushed him up against the metal-gated fence, put his hands behind his back, and twisted his arm. Agents released Gavidia only after he offered up his real ID. That ID was never returned to him. Less than 10 miles away in Whittier, immigration agents raided a car wash managed by U.S. citizen Jorge Viramontes. In the 9 days between June 9 and 19, agents returned 4 times to that car wash, each instance in the middle of the workday. On one occasion, an agent questioned Viramontes, the owner of this car wash, and requested that he show his ID. Viramontes replied that he is a dual U.S. and Mexican citizen and supplied his California driver's license. The agent said that ID was insufficient, grabbed his arm, escorted him to a vehicle, and drove him to a warehouse area for further questioning. Agents detained Viramontes for 20 minutes while they made calls to verify his U.S. citizenship and examined his Mexican ID before eventually driving him back to work. But other Operation at Large encounters have included even more force and fewer questions. Once again, this notion, this pie-in-the-sky Pollyanna notion that Kavanaugh writes about, and that's the law. That's going to be the law because that's how they're all going to write it when it comes down. If you're an American citizen, you're politely inquired as to your papers, and if you don't have them, or if you have them, then you're free to go. It's like it's a tea party. This is the lived reality of Operation at Large, and we all know this, the other ICE actions around the country. She goes on, Sonia Sotomayor. Agents pulled up in 4 unmarked cars to a bus stop in Pasadena. The doors opened and men in masks with guns started running at 3 Latino men who were having their morning coffee waiting to be picked up for work. Is there a reasonable suspicion there, do you think? How can we fight against these brutal un-American actions? Yeah, well, that's a very good question. When do we get stars? I mean, I feel terrible. I'm Irish pretty much all the way through. My mother-in-law is Indonesian by birth. Married a Vietnam era veteran. Lived there for 50 years, since she was a little girl, actually. But we're telling her, don't go out of the country. So these four guys having their coffee, rushed at by men with guns and masks, and no ID, no nothing, no reasonable suspicion. There's four guys having coffee. They're brown. That's all they would have known about it at that time, and ran at them. Latino day laborers, they were detained without anyone identifying themselves as ICE or police or anything else. And that happens again and again and again. So this operation sparked panic and fear, she says. Now, once again, the law can't go willy-nilly with every case. It's a blunt instrument. As Shakespeare said, the law is an ass. And it can be, and it needs to be so that it doesn't change with every judge and every case. But it has to be grounded in the factual reality of people's experiences, and not some airy-fairy notion that, well, if you're a U.S. citizen, you get to be let go right away. And so Sotomayor goes on to say there's that further evidence as to the government's actual intent and how these operations should be carried out, far once again from the pie-in-the-sky version of Brett Kavanaugh. Justice Sotomayor cites a Wall Street Journal article on June 9th. She said the plaintiffs submitted statements by federal officials regarding the government's law enforcement efforts. In late May, White House Deputy Chief of Staff Stephen Miller, my buddy again, reportedly told officers to, quote, just go out there and arrest illegal aliens, and directed them to target Home Depot and 7-Eleven stores. Senior immigration officials also told agents to turn the creativity knob up to 11, push the envelope, and if it involves handcuffs on wrists, it's probably worth pursuing. So, what should the law say, according to Sonia Sotomayor? Once again, the posture of the case is the district court has said, let's have a trial. The appeals court said, yeah, let's go have a trial. The Trump administration says, we don't want a trial. We want to keep doing this. And the Supreme Court just said today, yeah, we have a trial, but go ahead, keep doing it, to the Trump administration. And this is sort of Sonia Sotomayor's dissent. So she quotes the district court judge, there's a real and immediate threat that the conduct complained of will continue, and that the Fourth Amendment has been violated because officers cannot rely solely on generalizations that, if accepted, would cast suspicion on a large segment of the law-abiding population in Los Angeles. And Sonia Sotomayor goes on to say, yes, indeed, it would, because she goes after Kavanaugh. She says, Kavanaugh, in his opinion, which we took a look at the beginning here, has all but declared that all Latinos, U.S. citizens or not, who work low-wage jobs are fair game to be seized at any time, taken away from work, and held until they provide proof of their legal status to the agent's satisfaction. And I'm sorry, that is the ghost of Korematsu. Now, Korematsu was far worse, right? They were U.S. citizens. They took away their property. They took away their liberty for years at a time. Far, far worse. One of the worst things the court has ever done. Thank God it was overturned. It was not overturned until, I should look at it as if 2012 or something like that. Finally, Korematsu was good law, that you can round up people if you have enough of an emergency who are American citizens and intern them in concentration camps and take away their property. That was good law until a few years before Donald Trump was first elected. So thank God, because the thinking was, well, we'll never get into that situation again. There's no case to overturn it on. And finally, the court found a case where they could say, by the way, Korematsu's overturned. And we are lucky that they found that case and did so. So she goes on here. She says, what does the Fourth Amendment tell us, really? Yeah, it is just profiling and discrimination. There's no question about it. So the Fourth Amendment imposes limits on search and seizure powers. She says, as relevant here, the Fourth Amendment should mean that officers may stop an individual, quote, only if they are aware of specific, articulable facts, together with rational inferences from those facts that reasonably warrant suspicion that the individual may be illegally in this country. This requires more than an inchoate and unparticularized suspicion or hunch of criminal activity. So that's quoting, black letter Supreme Court law. You have to have a thought process. It can't just be, let's get him. He's brown. He speaks with an accent. It's got to be law, not force, but law. And that is what she is pleading for here. Critically, she says, a set of facts cannot constitute reasonable suspicion if it describes a very large category of presumably innocent people. Mexican ancestry alone, the court has found, is not enough. And she goes on to say that there are so many people in Los Angeles who are of Latino descent that really you're putting the great percentage of the population under the boot heel of fear. Here in Washington, right? I did a video story. Go look at it. It was fun to do, important to do. Talk to people all around the city of Washington. One of them, her mom's Vietnamese. And she's like, I don't want my mom coming into Washington, D.C. She's 80-some years old. She's a little slowing down. She doesn't know what a checkpoint is. She doesn't know what to do there. And so the entire Latino population of Los Angeles right now is potentially under this kind of scrutiny, this kind of gangster enforcement. That's the only thing to say. I'm all for enforcing the laws. But you've seen these guys. They just charge out, as happened in this case, without saying a word, and nab people, women and children as well. Allowing the seizure of any Latino-speaking Spanish person at a car, any Latino-speaking Spanish at a car wash in Los Angeles, tramples the constitutional requirement that officers must have a particularized and objective basis, right? Excuse me. She accuses Kavanaugh of just appealing to probability, arguing that the high prevalence of undocumented immigrants in the Central District should enable agents to stop a relatively broad range of individuals because there's so many brown people in L.A. is basically what he's saying. But she says, without even a citation, Kavanaugh claims that 10% of the population in the Central District is unlawfully present there, the Central District of California. So it is inevitable and unremarkable that immigration officers would target any Latino person or any person speaking accented English or any person standing in a particular type of location. She says, this is crazy. She says, never mind that 47% of the Central District's population identifies as Hispanic or Latino, and Brett Kavanaugh says police have at all of them. ICE have at all of them. Why not? It's cast a wide net. 37% of the population of Los Angeles County speaks Spanish at home. 37% of the population of Los Angeles County. Now think of the troops on the street there. Think of the ICE agents rushing at car washes and at bus stops. 37% of the population of that city speaks Spanish at home. Think of all the uniforms they're seeing, all the guns. And they know they're for them. 55% speak a language other than English because it's not just Spanish, right? My older brother, Jim, taught until this year. For 50 years, he taught English as a second language. He was a teacher at the high school level, private, public, all around Los Angeles. And he said that he taught at the East Los Angeles Community College. And every year he would delight in asking the class, which is dozens strong, how many different languages do we have here? And he'd go through it. And there were like 12, 15, 19 different languages. Los Angeles is what New York City was in the late 19th and early 20th century. It is a melting pot, a destination for people from all over the world. And 55% of the people in the city of Los Angeles County speak a language other than English. And so you cannot round up people. Under Supreme Court precedent, you can't have a rationale that will allow you to round up lots of people because, as the government said in that Brignone-Ponce case in 1975, the Puerto Rican fellow who was driving immigrants across the border, you can't just have a vague suspicion because it would cover a large volume of legitimate traffic as well. So how can this be? How can it be, she says, that given our laws and given how precious Americans have held their privacy from law enforcement? We're jealous, though. Every man's home is a castle. Every woman's home is a castle, right? Every person's home is a castle, however you want to say it. And our sense of our privacy. I'm going to call up just for a second. I know I've been going on and on and on, but I do think this is important. So the Fourth Amendment of the United States, think of the Constitution. These grand, magnificent generalities, as somebody once said, right? Freedom of speech, right? The Fourth Amendment is the most specifically written, the most detailed written part of the Constitution. And it says the following, right? The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons to be seized. So the Fourth Amendment, those old framers, they foresaw the danger in empowering a national government, and they wrote a very clear statement that doesn't necessarily bind immigration law, which has a slightly different. The Fourth Amendment applies to it, but not to the same degree as it does in criminal law, not in the same way. But the specificity of it declares the intention to protect us against sweeping law enforcement activity, against getting rounded up simply because of the color of our skin or the nature of our accent, or whether our work pays a lot or our work pays a little. And that's how Sotomayor basically concludes. She says, Operation at Large, that's the government's operation in Los Angeles, bears little resemblance to the hypotheticals that the government is claiming. The government has provided no evidence showing that its seizures were based on credible intelligence about a particular employer at a particular location. Indeed, the government submitted no evidence about what facts its agents relied upon to conduct most of the seizures documented in the record. Its declaration suggests that the government generally targeted locations based on types of businesses and the types of people who are there. And so I'll just flip to the end here because she gets very upset at the court in general. Once again, this is emergency relief. There's been no trial. Usually the Supreme Court says, slow down. We want the lower courts to develop the facts under oath, to test them in the adversarial process of a trial. Let it go up to the appeals court where they look at the various legal angles after the facts have been settled, so that the whole thing arrives at the Supreme Court pretty thoroughly litigated, so they can get a handle on what's there. I've been in arguments at the Supreme Court where it was clearly, it came too fast for them, or there's something they can do called improvidently granted. They can dismiss a case based on the improvidently granted certiorari. In other words, they shouldn't have taken the case because it comes up to them and they realize, wait, this is a mess. We can't get our hands on it. But 16 times now, they have basically said to the Trump administration, you go ahead with these kinds of activities because even though we don't really have a grasp on how bad they might be, we'll let the trial court have that trial. And then post facto, after the people have been arrested, after the American citizens have been locked up, then we'll take a look at it. And so she says the on-the-ground reality contradicts the government's claim of a chilling effect. One of the things that Kavanaugh says, whoa, we can't allow this district court's order to remain in effect and stop this operation, which is very important to round up illegal aliens, because the government will stop. Nothing will happen. This struck me. I didn't hear this. I had not heard this. Since the issue of the temporary restraining order, since the issue of the district court's order for the government to stop the activities that ICE was engaging in, listen to what's happened. Secretary of Homeland Security Kristi Noem has called the district judge, quote, an idiot, very typical of this administration, and vowed that, quote, none of the government's operations are going to change. Again and again and again, see the thing in front of you and name it. The thing in front of me is defiance of the court. A constitutional crisis. Amy Coney Barrett just wrote a book saying there's no constitutional crisis. Well, she's part of it as far as I'm concerned. But certainly, how can you? This is the Secretary of Homeland Security who has been enjoined by a federal district court. You must stop these enforcement activities until we can see factually in the course of a trial how they are operating, apply the law to them, and then you can appeal. She lost it and she said, we're going to continue. And it wasn't until today that they would lawfully continuing. They've been breaking the law every single day since July when the district court's opinion came down. So that's Kristi Noem, the CBP chief patrol agent in the Central District. The guy's, running that part of this operation has stated that his division will, quote, turn and burn and go even harder now. That's so Trumpy. And has posted videos on social media touting his agents' continued efforts, quote, chasing, cuffing, and deporting people at car washes. So this is the law enforcement officer in charge posting on social media, boasting that he's breaking a court order. Justice Sotomayor concludes like this. It is the people of Los Angeles and the Central District who will suffer from this court's grant of relief to the government, allowing the government to continue these things. Immigration agents are not conducting brief stops for questioning, as Kavanaugh would have it. They're seizing people using firearms, physical violence, and warehouse detention. Kavanaugh, she says, relegates the interests of U.S. citizens and individuals' legal status to a single sentence, positing that the government will free these individuals as soon as they show they're legally in the United States. That blinks reality, she says. Two plaintiffs in this very case tried to explain that they are U.S. citizens. One was then pushed against a fence with his arms twisted behind his back, the other taken away from his job to a warehouse for further questioning. So she says there may be good justification for issuing this kind of rapid order cutting off a district court. Yet some situations simply cry out for an explanation, such as when the government's conduct flagrantly violates the law, or when lower courts and litigants need guidance on the issues on which they should focus. And she concludes by saying, for the Fourth Amendment protects every individual's constitutional right to be free from arbitrary interference by law enforcement officers. Once again, quoting that 1975 case. After today, that may no longer be true for those who happen to look a certain way, speak a certain way, and appear to work a certain type of legitimate job that pays very little. Because this is unconscionably irreconcilable with our nation's constitutional guarantees, I dissent. So that's Sonia Sotomayor. I mean, who do you think won that argument? I don't think there's a question. Now, I'm not somebody who thinks that, the court should get in the way of the people's choice for president. Donald Trump is the president of the United States. But I do think when presidents overstep their boundaries, overstep their powers under the Constitution, the court should step in and stop them. I thought Biden overstepped his powers when he forgave billions of dollars in student loan debt without an act of Congress. Some things got to get done democratically. I think Barack Obama was right when he said for the first 4 years of his 8-year presidency that he did not have the authority as president to legalize the dreamers, right? To allow those people who came to the United States as children and their parents unlawfully in the country, that he did not have the authority as president to reconcile their condition. In the second term, he said, the heck with Congress, it's broken, I'm going to do it myself. I think that's beyond the scope of presidential authority. You need an act of Congress. This, too, seems pretty clearly more serious. This is beyond the scope of the Fourth Amendment. It seems to me that Sotomayor carried the day And what it shows and tells us about the Supreme Court is that they want no part of seeing what is in front of them, actually seeing what's in front of them. They want no part in naming it, the majority on this court. They will pretend that it's business as usual. They won't look at that masked and armed ICE agent cuffing the American citizen. They won't look at that masked and armed ICE agent tearing the mother away from the child. They'll look at their case law. They'll find, you're always able as a lawyer. A good lawyer can argue every side of every story, of every case. And I think we are going to hear a lot more green lighting. I think on birthright citizenship, they're going to strike down that executive order. They'll stop them in a couple of places. But their feeling is the Constitution empowers the president as the executive to carry out his duties as he sees fit. And the law is loose enough to allow him to do these things, and we aren't getting in his way. The final point I'll make is one that I made in a piece I wrote a few weeks ago. I think it was called Our Clueless Court. This court is not meeting the moment for us. And the reason is they aren't really big enough for it. This is a court, not to put too fine a point on it, mostly of dweebs. People who lived cloistered, privileged lives, going to excellent schools, joining law firms for a while, really practicing in the appellate courts, the hush of the appellate courts, far away from where the law really lives. In the lives of those people, many of them U.S. citizens now living in fear in Los Angeles and elsewhere. It's Justice Sotomayor who cries out for the rest of us, essentially, to do what the court cannot. See it, name it, act on it. I love doing this for you guys. I hope I'm not going on too long, but I probably do. Now you know how my wife and children feel. But I think it's important. I thought today was a really important day in the court. And the Sotomayor versus Kavanaugh debate shows you what's going on up there and what we need to do about it, which is really stand up and just tell the truth about what we see. I want to thank you. If you like it, if you want to become a paid subscriber, there'd be nothing better for me. But most importantly, hang in there. There's a lot of work to be done. And some of it is just putting this in our minds and hearts and standing up for what's true and right. And know that someday, this shadow will pass and all the people who were involved in these terrible events will be held accountable by history, maybe by more, but certainly by history, by our children and grandchildren who will be proud of you. You stood up and did the right thing. Thanks very much. Till next time.